The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and welcome to our webinar today. We're really pleased that you could join us. And today we're going to be talking about sort of the top 5 costly HR compliance tripwires, things that really affect all employers. And we'll talk a little bit about how you can avoid tripping those wires and running into some compliance issues. A couple of quick housekeeping items. We are in GoToWebinar. Audio is often better if you're on the phone. But if you have any technical difficulties, you can chat or submit a question, and we have Jolene and Caitlin with us who would be happy to get back to you and help you with any technical issues while we're moving forward with the webinar. Today's webinar is sponsored by our BLR's HR Comply 2018, which is our annual compliance conference. If you've been with BLR for a while, you know that we had a conference called the AEIS, our Advanced Employment Issues Symposium. So we've rebranded that conference this year as HR Comply. We're going to be in Las Vegas, November 14th to 16th. So I hope we can see some of you there. So what Joan and I are going to be doing, we'll introduce ourselves in just a minute, is talking to you about some of the as I said, the most sort of hot compliance topics right now. And also topics we'll be covering in depth at the conference in November. Let's go ahead and we'll get started. First, I just want to tell you a little bit about myself, and then my co-presenter, Joan, can talk to us for a minute about her. I will not read all of this, I promise. My name is Catherine Gray. I'm an attorney, and I'm also BLR's Senior Managing Editor for HR and Compensation. And we have a team of legal editors who work at BLR. We're all lawyers with labor and employment backgrounds, and we work on all of the content for our events, as well as HRBLR.com, HR Hero, and some of our other platforms that provide you with the information you need to do your jobs well. So I started off my career in HR, worked as a management side labor and employment attorney in private practice, and now I'm with BLR. So I'm excited to be with you today. And now I'd like to introduce Joan, or have Joan introduce herself.
At BLR, I write mostly in the topics of discrimination and harassment, where there is never a dull moment. So that's the fun part of my job. I also am the editor of some of BLR's ADA products. And before I came to BLR, I worked as in-house counsel for a multi-state employer, providing counseling advice across several states for management. And that gave me a real appreciation for the issues that multi-state employers can face. I'm going to turn it back over to Kathy.
Thanks, Joan. So we're going to go ahead and jump right into our presentation today. And I wanted to first let you know what we're going to be covering, a little bit about that. And so we're focused on limiting liability and helping you drive success. And here's the topics we're going to talk about today. The first one I'm going to talk about is navigating paid sick, parental, and family leave. If any of you are in a state where you have paid sick leave laws, or a city where you do, or a state where you have your own family medical leave law, or in multi-states, you know what a difficult situation that can be. Joan's going to talk with you about #MeToo and how we need a culture shift on sexual harassment. And again, Joan spends a lot of her time at BLR working in the area of Title VII, discrimination, sexual harassment. That's one of her areas of expertise. I'm going to go over some of the latest compliance hurdles for federal contractors. Joan will talk about legal pitfalls in recruiting and hiring, which we've had a lot of new laws lately. And then I want to end with a discussion around severance agreements, when to use them, and how to minimize the legal risks. And that actually brings in some issues from the Me Too movement as well. Just a quick note, as I mentioned up front, these are topics as well as other critical compliance topics will be covered in depth at our conference in November. Things like we're expecting overtime regs in October, new proposed overtime regs. So a lot of other issues, obviously, on the front burner for employers to think about that we're not going to be able to cover in the time we have here. So I want to start and sort of just give a quick overview or talk about the different leaves that we're all faced with right now as employers. And I put a leave for every season because it does seem like the number and kinds of leave laws we have are just multiplying, and it depends on your state, obviously. So we obviously have the Federal Family and Medical Leave Act, which applies to all employers that have 50 or more employees. And then eligibility requirements are a little different. I'm not going to go into the details of the FMLA, but if you haven't 50 or more employees, you're likely covered by the FMLA. And that requires you to provide 12 weeks of unpaid leave to individuals who qualify for that leave. So employees, serious health condition, birth of their own child or placement of a child for adoption or foster care, serious health condition of a qualified family member, including their spouse or child. And so that's up to 12 weeks of unpaid leave. And then we have this sort of myriad of state and local laws. Number of states that have family and medical leave laws of their own, and we'll talk about that as well. Maternity leave laws, we're seeing a lot more activity on the maternity leave side as well, not just requiring leave, but also accommodating pregnancy. So this is a very active area. And then paid sick leave and at the state and local level, at the state and local level. We've seen, in the absence of something at the federal level, a whole lot of activity on the state and local level in this area. And then other leaves, things like military leave. You have leave for victims of domestic violence. You have everything from leave to attend functions at your child's school, leave for bone marrow donation. So there's a lot, depending on your state, you may have a lot of different leaves that apply to your employees. So this really is an area that requires a lot of attention and effort on the part of employers. So I want to spend a minute talking about the interaction between federal and state family and medical leave laws. So generally, these are the laws, we know we talked about the FMLA, but that require employers to provide some period of unpaid leave to employees under certain circumstances, childbirth, to care for a family member, things like that. So 10 states and the District of Columbia actually have their own family and medical leave laws or family leave laws. Some of them, I think New Jersey, it's a family leave law. So the reason you can take leave are for caring for a family member or to bond with a child. That's not a medical leave law. So there's some differences there. But so that includes District of Columbia, California, Connecticut, Hawaii, Maine, Minnesota, New Jersey, Oregon, Rhode Island, Vermont, Washington, Wisconsin. So if you're in any of those states, you have a state leave law to consider. Often those state leaves, many of them actually are very similar to the federal family and medical leave. Connecticut, which is my state, actually requires employers to provide up to 16 weeks of unpaid leave in a 2-year period. So you really have to be familiar with what's happening in your state, especially if you're in one of those with a family leave law. Let's see, so then we have another layer on top of that, which is state laws that provide for some or all of that state family leave to be paid. So that would include Rhode Island, California, New Jersey, New York. District of Columbia and Washington have both passed laws effective in 2020, I believe that's right. And so those laws vary a little bit, and you need to be familiar. See, California is one that has quite a scheme of leave laws, including paid leave. But often you'll find New Jersey, I think, is like this. They fund that leave through something like an unemployment insurance fund. So contributions by employees into the fund, and then when they need to take leave, they get paid through the fund some portion of their pay, whether it's 60% or whatever that formula is in that state. Some of them the employees can decide to contribute or not, and then that depends on whether they're eligible for the paid leave. But there's definitely a movement to provide some type of paid FMLA leave. There's been a movement at the federal level. I think it's Ivanka Trump, right, Joan, who's been pushing hard to get some kind of paid family leave or paid maternity and paternity leave. There's been proposals out there at the federal level. Actually, there was some proposed legislation that would have provided for, I think it was 6 weeks of paid leave. And in that law, a state could opt out of, or an employer could opt out of the state specific requirements and provide the federal leave. So that has not passed through Congress and gone anywhere yet. But there's a little more effort at the federal level. We're still seeing lots of activity at the state level, however. We both enact family medical leave laws and to provide some type of scheme for paying that. So a key point to remember here, if you're in one of these states where you have federal FMLA, state FMLA, or FLA, and some paid scheme on top of that, that you really need to sort of look at each one of those. So if you have an employee who's going out on leave, you want to stop and say, okay, at first, is this employee qualified for leave under the FMLA? And if the answer to that is yes, you have to make sure you're following that leave law. And then, do you have a state law? And if so, is the employee qualified for leave under the state law? If the answer is yes to both of those, you really look at them both. So Connecticut is kind of funny because if they haven't taken any leave recently, they're going to be entitled to 16 weeks of leave in a 2-year period. Let's say that same employee the next year, and that would be under Connecticut state law, more generous than federal law. But let's say the next year, so we're only 12 months down the road, the employee needs leave again. They're not eligible now for Connecticut leave because they've taken that 16 weeks in the 2-year period. But since 12 months have passed, they're now eligible for 12 weeks of leave under the federal law. So it's really important that you look at each situation and look at each one and see what they're qualified for. And again, the one most generous to the employee, because you always want to make sure if they're qualified for 2, you're designating them to run concurrently. The leave is designated both as federal and as state, if that's applicable. And then after you've figured that out, are they qualified for some type of paid leave for all or part of that leave? And so it really is a step-by-step analysis that works best. Maternity leave, I want to touch on this briefly as well. So we have obviously federal and state family medical leave in most cases cover maternity leave, both for a woman who is unable to work because of pregnancy or recovering from childbirth, but also to bond with a new child. State laws, in addition to family and medical or family leave laws, there are a lot of states that may not have those laws that actually do require you to provide some type of reasonable leave, maternity leave, to an employee, generally up to 6 to 8 weeks following childbirth. Or if they don't have that, there is a requirement, and it's generally a requirement, non-discrimination, that you provide a woman who needs maternity leave for her own condition, right, or to recover from childbirth, in the same basis, both the leave and the benefits, as you would to an employee who's out of work for another reason on short-term disability. So you can't distinguish between those conditions and benefits. And then we have this group of laws coming on the books now in the last couple of years requiring pregnancy and maternity accommodations. Both the ADA and EEOC has taken the position that employers have to accommodate a woman who might have a condition related to pregnancy. But a lot of the states have also enacted laws now, so you want to, again, be very careful to look at what your state requires. And also things like accommodations for a woman who's lactating at work and who might need to express milk, things like that. And so, again, a lot of laws you need to be aware of. And then paid sick leave mandates. I think I'm running over my allotted time for this topic, but that's okay. It's an important one. Paid sick leave mandates are another thing that I mentioned up front. So we really don't have a federal law right now that requires employers to provide paid sick leave or even to provide sick leave for that matter. It's really something that as a federal law for private employers we're not regulating. In 2014, there were actually only 4 paid sick leave laws on the books. Connecticut was one of the first. And I think Connecticut, if I get this right, 2009, 2010, it might have been 2010 it came on the books. Maybe it was a little later than that. I know I was in private practice and I worked with employers to bring their PTO policies in compliance with this law. And Connecticut is a law that I think a lot of the other states have based theirs off of how it gets accrued, reasons you can use it. In 2018, as of right now, we have 11 state paid sick leave laws. That includes the District of Columbia, and those are noted here. And I think the most recent one, New Jersey, just enacted one, which will come online later this year. And if you look at the next bullet I have, there were currently 19 local paid sick leave laws across the country. So federal law, we didn't have a law. States got in the act. Where states were unwilling to act, and New Jersey was one of them until this year, local governments were acting So New Jersey actually had and has right now approximately 13 local laws. And if you have employees within those local areas, you have to provide sick leave based on that local law. And they all are a little different. New Jersey finally enacted a state law. It will become effective October 29th of this year. And when it does, the law specifically says it will preempt all of those state laws. So that's actually going to make things easy for a New Jersey employer, especially one who has multiple facilities at different locations. Another example, California has a state law and also 7 local laws. So if you're in California, you have to comply with the state law, but if you're in one of these cities, you also have to worry about the city law. So this paid sick leave, the paid sick leave management is very complicated. Washington or Oregon, I think it's Washington State, same thing, a state law and several local specific laws. Illinois, no state law, but you've got Cook County and Chicago. So these are cropping up all over the place. And it's something you really want to be aware of. That's what I wanted to go over on leaves real quickly. Joan's going to pick up in a minute on the Me Too movement. I did want to mention to you, Kara Shea, who's the partner with Butler Snow, actually out of Tennessee, and Kevin McCormick, who's with Whitford, Taylor, and Preston, are the people who are going to be talking about this in depth at HR Comply, this whole topic of the paid sick parental and family leave hotbed. So.
Thanks, Kathy. Okay, so sexual harassment. It seems like nearly every day there's a new story in the news about sexual harassment allegations against a celebrity, a political figure, and the Me Too and Time's Up movements have raised awareness of the pervasiveness of sexual harassment in the workplace. Harassment persists in the workplace, despite the fact that federal and state laws prohibiting sexual harassment have been around for years, and despite the fact that employers have been providing their supervisors and managers with training on what sexual harassment is and how to prevent it. A report published by the EEOC last year revealed that about 70% of employees who experienced workplace harassment never talked with a supervisor, manager, or union rep about the harassing conduct. So employers have these strong anti-harassment policies in place, but most employees aren't reporting harassing behaviors to their employers. So where's the disconnect? According to the report, most employees don't report sexual harassment because they think it's not worth the risk. Employees think they're going to be labeled as troublemakers, that they won't be believed. They worry about retaliation. They think nothing will be done to change the situation. And this may mean that employees don't trust their employers to manage their sexual harassment complaints with respect. And that can point to a need for a change in company culture, because employees need to trust that their employer will stand by its policies. And it doesn't matter who's being accused of harassment, regardless of whether it's a well-liked manager or a high-level executive or a sales rep who makes a ton of money for the company. So an employer's policy against workplace harassment has to have buy-in at the highest levels in the company. All levels of management have to be on board, from frontline supervisors to C-suite executives. And all management levels and all employees should be provided with harassment prevention training, not just managers and supervisors, because employees need to know what sexual harassment is, what the employer's policy says about it, how to report it. And an employer's policy against sexual harassment should explain what the company considers to be inappropriate behavior, not just what unlawful sexual harassment is. And that's important because if an employee complains about behavior that violates the employer's policy, even if the behavior doesn't rise to the level of unlawful sexual harassment, the employer can take disciplinary action. And taking that kind of action to enforce your policy helps to send a clear message to employees about the kind of behavior that's acceptable and unacceptable, and what fits with your company culture and what doesn't. So the same is true for abusive behavior or bullying. Abusive behavior that isn't based on a protected characteristic like race or color or sex isn't unlawful, and we're all familiar with, the equal opportunity harasser who's just nasty to everybody. But just as an employer would address unprofessional or inappropriate behavior, bullying or abusive behavior by a supervisor needs to be addressed. And a company that tolerates abusive behavior because a supervisor runs a department that turns out really good numbers, that sends a clear message to employees about what the company values. An employer can have a code of conduct in addition to a policy against sexual harassment, and the code of conduct is a great place for employers to capture and set forth what their values are, what the company's values are, and what their expectations are for appropriate workplace behavior. An employer's reporting procedures can also speak volumes about its company culture and its views on harassment complaints. If your company wants its employees to report inappropriate behavior and harassment, it's important to make it an easy process. And for example, it's not going to be easy for an employee to report harassment to her supervisor if the supervisor is committing the harassment. So incorporating things like multiple channels, alternate avenues into your reporting procedure is critical. Employees need to know that if they can't talk to their supervisor, they can go to HR or to another supervisor, whatever you set out in your process. And a reporting procedure should also encourage reports by an employee who's witnessed workplace harassment but wasn't necessarily the target of the harassment, because if an employer values a harassment-free workplace, it's going to encourage all employees to report harassment when they see it so that it can be addressed. And supervisors need to know what to do when an employee comes to them with a harassment complaint. A supervisor needs to walk the talk or take action that's consistent with the employer's policy when the supervisor responds to a harassment complaint. The employer's policy says it encourages employees to come forward, then that should be reflected in how the supervisor responds to an employee who makes a complaint. And when you look at cases, there are hundreds, probably thousands of lawsuits in which employees or former employees testify that when they tried to report harassment, they were told that they needed to learn to take a joke, that they should ignore the harassment, and they were otherwise discouraged from reporting harassment. So employers need to convey the message to supervisors that the company wants employees to report harassment. This is not something to be avoided. They want to know about the harassment so it can be addressed. It's also important on the legal side for supervisors to know that once they've been told about possible harassment, that triggers legal obligations for the employer. If an employee comes to a supervisor and complains about harassment, but asks the supervisor not to take action, to keep the complaint confidential, supervisors need to have training so they know what to do. Under federal law, under Title VII and the laws in most states, employers are required to conduct a prompt and thorough investigation once the employer receives the harassment complaint, and to take steps to stop the harassment and to prevent it from happening again. So a supervisor must take action because he or she is legally required to do so, and that can be communicated to the employee. And confidentiality can't be guaranteed because certain information will need to be disclosed in the course of an investigation. So the bottom line, the first action the supervisor should take after receiving a harassment claim or complaint should be to contact HR. HR will determine the next steps, and can give the supervisor guidance. And finally, employers need to take steps to prevent retaliation against an employee who's complained about harassment. Employer can be legally liable for retaliation, even when the underlying harassment claim turns out to be meritless. So it's not surprising that more retaliation claims are filed with the EEOC than any other kind of discrimination charge. And returning to company culture, a company that values a harassment-free workplace and values reports of harassment so that it can address inappropriate behavior should value an employee's ability to report harassment without fear of retaliation. It should be part of the company culture. Federal and state laws generally prohibit employers from retaliating against an employee who is engaged in protected activity. Protected activity can range from filing a charge, being a witness in an investigation of a charge. It can also include communicating with a supervisor or manager about employment discrimination, including harassment. And retaliation can take a lot of forms. It can be a demotion. It can be increased scrutiny. It can be a transfer to a less desirable position. It can be a negative performance evaluation that results in an employee getting less of a raise. Any action that could reasonably deter a person from engaging in protected activity may be considered retaliatory. Steps that employers can take to prevent retaliation include requiring additional approvals for actions taken by supervisors who've been accused of harassment. You can keep information about the harassment complaint as confidential as possible. Train supervisors about actions that can be considered retaliatory, and take action as soon as possible if you discover that retaliation has occurred. So sexual harassment, we can see just from the news, it remains a compliance issue for a lot of employers, and a lot of employers are looking for ideas that will help them achieve a harassment-free workplace. And this may require changes in policies and steps that will make training more effective. And as you can see at the bottom of the screen, Susan Fenton at HR Comply this year, she will be doing a full session on the topic. She is with the law firm of Scholar Rabbit and Presser. And Susan's going to cover, going to talk about the kinds of workplace culture that can make an employer vulnerable to harassment claims. She will discuss strategies for preventing bullying, how to encourage bystander intervention, and a host of other practical ways to change workplace culture. Susan has a lot of experience as a labor and employment lawyer, advising and representing employers. So she has a lot of practical advice that employers can put to use. And that's it for my sexual harassment section. I'm going to turn it back over to
Thank you, Joan. Just a quick word, too, on Susan. You know, Susan does a lot of writing for BLR, and she wrote an article not too long ago after the whole Me Too movement really percolated up. She really talked about her own experiences with sexual harassment as a partner in a law firm, and I won't say how many years ago, but quite a few years ago, before things were even changing, when women were not as prevalent in law firms. Her own, and she's not that old, I made her sound very ancient, I know, but her own experience. But she also talked about how she's making big changes and how she's delivering sexual harassment training now, and the importance of civility training, which the EEOC has also put some emphasis on. So very interesting times we're in. I know as a lawyer who's given sexual harassment training over the years, thinking about how we change that. So I want to take a quick minute and talk about federal contractors in 2018, and this is actually probably one of the quicker topics we'll have today. And if you are a federal contractor, you know the difference in the landscape from 2016 to now, or 2015-16 during the Obama administration to now, is very significant, right? Because under the Obama administration, we saw executive orders, quite a few of them, lots of new requirements for contractors. Some of them remain in place today, and I'll talk about those in a few minutes. And then some things have been dialed back a little bit as well. So I think right now a couple of the big sort of shifts at the OFCCP that I wanted to mention. First of all, there was a study that had been done with contractors, and one of the big things that had been noted was the adversarial relationship between the agency and the government contractor community, right? Not really a partnership, but more of an enforcement stance under the Obama administration. Auditing, enforcement, complaints being filed. And so under the new administration, the OFCCP has said that they're going to make efforts to create and maintain a better relationship with the contractor community. So not as much focused on enforcement as much as focused on education and working with contractors to make sure they're in compliance. So a feeling that that's going to change. We hadn't seen a lot of directives out of the OFCCP yet, but we did have one come through very recently, Directive 2018-1, first one this year, which requires the OFCCP offices to adopt a uniform approach to their predetermination notices. And what we've always found is across the country, the different offices had different ways of doing things. And these are the notices when you've had a compliance audit and there's a finding of some kind of violation, that predetermination notice. So going forward under this directive, the OFCCP, local agency doing that audit, needs to inform a contractor of the agency's preliminary findings of employment discrimination. So if that audit's been done, investigation's been handled, and there's a preliminary finding of employment discrimination, the contractor gets informed, and then the contractor has 15 days to rebut that preliminary finding through providing evidence, testimony, whatever it is, before that notice, that finding becomes final. And so, again, I think it goes in line with that better relationship, a little more collaborative process. Clearly, if there's a serious incidence of discrimination, that 15 days probably won't make a difference there. But I think it does working together more, and that's probably the most major directive that's come out now in the new administration here. So what are the issues for federal contractors in 2018? Well, we saw under the Obama administration, they had added the pay data collection element to the EEO-1 report. That was scaled back late in the process, back in the fall. The pay data collection portion of the EEO-1 was removed. That was no longer a requirement for employers. The deadline to file was moved to March 31st before that to accommodate that pay collection. And that was the deadline that was in fact in place for filing your 2017 reports, was March 31st, 2018. Interestingly, after that deadline, the OFCCP, kind of without any fanfare, extended the deadline to June 1st. So if you're not aware of that, if you have been, I won't say delinquent, but delayed in filing your reports, you have until June 1st to actually do that. And some investigating I did shows that one of the issues was in the new directions for the EEO-1, they talked about you always had to report people based on the address where they worked, but it was always interpreted as the employer's place of business. The instructions talked about reporting if you had them working at another location. So let's say you're a government contractor, your employees are working at, in Connecticut, the submarine base here in Connecticut doing some work, would be reporting them at that address. And there was a lot of confusion over what that meant. And add to that some changes to the EOC database here, and that caused some glitches. I think those are the reasons that we've extended that deadline. The instructions now say you can report those employees if they're working at a client site, either at the client site address or the address where they report to. So for this year, you have that option. We're not sure how it's going to get handled for next year. They say that they're going to better define that. And we'll see. We also don't know if the deadline for the filing reports might go back to September 30th or it's going to remain to March 31st. There hasn't been a lot of information here, but I was surprised to find that deadline moved out to June 1st. And again, with very little publicity around it. Immigration enforcement, this is just an area I want to mention. Obviously, this is a big area for the Trump administration. For government contractors, making sure your I-9s are in place, making sure you're following all the requirements, they're very important. Many, not many, but depending on the type of contract you have, you may have special requirements for security and other things. Obviously, those issues will already be taken care of. And then a lot of the other requirements, new things that came up under the Obama administration, they still remain in effect, and we actually expected some of them to be rolled back. Now, one was rolled back I don't have on here, and that was the, and now I'm forgetting what we were calling that rule, but it was the rule that would require employers, as part of the contracting process, to report any claims of discrimination they'd had in other employment claims. That was taken off the plate, so to speak, right after the Trump administration came into office. But paid sick leave for government contractors, the only federal law other than federal employees where there's a paid sick leave requirement. Minimum wage is higher for government contractors, and it's stepping up each year until it reaches, I think it might be 15. I'm going to have to go look that up. So your minimum wage is gone up January 1st the last couple of years. And then we still have a prohibition against discrimination on the basis of sexual orientation, transgender status, and gender expression in the military. I mean, for government contractors, excuse me. The military, it's gone back and forth. I'm not even trying to keep up there. But for government contractors, and again, there's a lot of discussion right now whether those groups are protected under Title VII. The EEOC says yes. Some courts have said yes. The Department of Justice says no. And some courts have said no. So we're expecting that's going to continue to be a battle. But for government contractors, there's an executive order in place that protects individuals on that base, employees. And again, I want to mention Mickey Silberman from Fortney Scott. If you're not familiar with Fortney Scott, they're a Washington, D.C. law firm. They do webinars for us on a quarterly basis for government contractors. And they have an extraordinary view on what's happening in Washington, D.C., and a lot of inside information on what's coming up. So a contractor, he's an incredible resource for that. So I'm going to hand this back to Joan. She's going to talk to you about recruiting and hiring, which is another active area right now.
Okay, thanks, Kathy. We're going to start at the beginning of the hiring process with application forms. The first step for most job applicants is completing an application form, sometimes online, sometimes hard copy. But either way, the application form is a way for employers to gather basic information to determine if an applicant has the basic qualifications for the job in question. And often these forms contained a question asking an applicant to check the box if he or she had been convicted of a crime. But over the past few years, more and more states and cities have passed laws that prohibit employers from using an application form to ask applicants about their criminal history. These laws are referred to as ban the box laws because they prohibit employers from having that check the box question on their application forms. As of last month, 31 states, the District of Columbia, and over 150 cities had enacted some kind of restriction on employer inquiries about an applicant's criminal history. Some laws apply only to public employers, some apply to both public and private employers. And of the 31 states, there are 11 that have restrictions that apply to private employers. And of the cities, there are 17 that apply to private employers. So while those numbers seem small, they don't tell the whole story, because currently almost 3/4 of the U.S. population now lives in a jurisdiction that has a ban the box law. So the laws affect a lot of employers. Typically, the laws have exceptions for certain types of jobs like law enforcement, those that involve working with vulnerable populations like children or the elderly. And also, pretty typical of the laws is the restriction that applies to employers in the application form in early stages of the hiring process doesn't continue throughout the entire hiring process. An inquiry about an applicant's criminal history is permitted. You just have to wait until later in the hiring process. In some jurisdictions, employers have to wait until after the first interview. In other jurisdictions, employers have to wait until after they extend a conditional job offer. Some jurisdictions have other requirements. They prohibit employers from stating on a job advertisement that a background check is required. Some states require employers to weigh certain factors when they consider an applicant's criminal record. And some require employers to take additional steps if an applicant has a criminal record. And this often includes notifying the applicant about the criminal history report and offering the applicant a chance to explain extenuating circumstances or rehabilitation. So each law has its own idiosyncrasies. So it's important for employers to check state and local requirements in the locations where they operate. Another question that often shows up on application forms asks about an applicant's pay history. It's another area where employers need to be aware of recent legal developments. There are currently 4 states that have laws prohibiting private employers from asking a job applicant about his or her pay history. And they're listed there: California, Delaware, Massachusetts, and Oregon. And on the local level, there are a few big cities, for example, New York City and San Francisco, that have ordinances prohibiting private employers from asking about pay history. So employers, and in particular multi-state employers, need to know the requirements of the state and local laws. The laws prohibiting salary history inquiries generally are designed to reduce the wage gap that affects women and minority workers. And the idea is that women and minorities generally enter the job market at a lower starting rate than white men, and the lower rate follows them as they change jobs because some employers base the starting pay on the applicant's prior salary. Federal law under the Equal Pay Act prohibits employers from paying women less than men for equal work on jobs that require equal skill, effort, and responsibility. There are exceptions that include differentials based on a seniority system, a merit system, a system that measures earnings by quantity or quality, or a differential based on any factor other than sex. And this last catch-all exception has been used by employers to defend a pay differential that's based on a woman's prior salary. Some courts, like the 10th and 11th circuits, have weighed in, saying that a person's prior salary alone can't justify a pay disparity. And just last month, the 9th Circuit ruled that as a matter of law, salary history is not a factor other than sex under the Federal Equal Pay Act. So it will not fall within that catch-all category. So employers that are in the 18 states covered by those circuits can no longer rely on a female applicant's prior salary to explain a wage differential. Going forward, it may be a better idea for employers to determine the market value of a job, establish a pay range based on a person's experience and skills, and then use that to set an applicant's starting salary. All right, let's look at background checks. We've already talked about ban the box laws, so we'll talk about some of the other information an employer might get through a background check. Some employers, as part of the hiring process, run background checks that include a credit report. This may be a violation of state law in about 12 states. And as with criminal history inquiries, there are exceptions built into the laws for jobs that include handling cash, jobs that provide access to confidential or proprietary information, and again, jobs that involve working with vulnerable populations. Employers need to be mindful if they use a third party to get a consumer report. They must comply with the Federal Fair Credit Reporting Act. It has several requirements, notices, and authorizations, consent that must be obtained before an employer can obtain a report. Social media screening is growing in popularity, and employers are justifiably concerned with the legal risks of screening applicants by using social media. Some experts suggest using the model set up by ban the box laws if you are going to use social media to screen applicants. And that means waiting until later in the hiring process, until after the first interview or after a conditional job offer has been extended, and use the social media review as part of your background check. And the timing is important because characteristics like race, color, age, disability, and national origin will already have been revealed to the employer. But employers need to keep in mind, too, that characteristics like sexual orientation, religion, pregnancy, marital status, parental status, relationships with those in protected classes will not be and should not be disclosed during an interview, and that those kind of characteristics can be revealed in social media. So if an employer does decide to use social media as a screening tool, it's a good idea to have HR do the background check instead of a hiring manager, so the information can be scrubbed. So only relevant information is given to those who are making the hiring decisions. So that way, if a social media check reveals that an applicant is pregnant, for example, the HR manager can keep that information confidential. Limiting search to network sites like LinkedIn, where people keep their posts generally on a more professional level, is probably a better idea than using an online search engine to see what turns up when you search an applicant's name. And it's also important to keep in mind that mistakes happen. The internet is not infallible. Sometimes online information is incorrect or has been maliciously posted by someone else. So if employers want to go down the road of using social media for screening, they should consider allowing an applicant an opportunity to explain or refute any information that the employer relies on when making a hiring decision. And keep in mind that we are talking here about publicly available information. There are several states that prohibit employers from asking applicants for their user IDs or passwords, or asking applicants to open their social media accounts so that the employer can do what they call shoulder surfing, stand behind them and take a peek at the screen to see what the applicants posted. And legal risks aside, employers really need to consider whether social media screening fits with their company culture, with the image that they want to convey. Applicants may feel that social media screening is too invasive and that the employer is not respecting their privacy. So I've talked about just a couple of areas where recent legal developments can trip up employers during the hiring process. You can see at the bottom of the screen at BLR's HR Comply conference this year, Kathleen Yonohara, who is a labor and employment attorney with the law firm of Freeland, Cooper & Foreman, will present an entire session on recruiting and hiring. She'll cover the do's and don'ts for background checks, how to use social media for recruiting, what you can legally ask and can't ask during an interview, and best practices with regard to the pre-offer and post-offer stages of the hiring process. Kathleen has years of experience practicing employment law, and she's a great presenter. So her sessions are a really good way to get the most up-to-date information along with practical advice. Okay, I'm going to turn it back to Kathy now.
Thank you, Joan. Yeah, you know, we've mentioned these presenters, and I will say, you know, we're giving you a good overview of the issues, some of the hottest issues, but you have the opportunity, obviously, at a conference to spend some time getting your questions answered as well. And Kathleen is great at that. So the last topic we wanted to cover, and we should have just enough time, this is working out well. The last topic I wanted to talk about was severance agreements, which, you know, I've been practicing law and in HR for a long time. I think my bio says 20 years or more, but it's actually just a little longer than that. And been writing severance agreements and working on, you know, when we've done group reductions in force, poor performance, termination. And it's surprising to me that they still remain, that they've sort of, there's all the issues we've always had with severance agreements, but there are new ones now and some new considerations we have to think about as we think about those agreements. So first, I just wanted to quickly review when are we using these? So severance agreements generally are used for involuntary terminations. So if you have a job elimination, sometimes that's one job you're eliminating, and that shouldn't be confused with terminating someone for poor performance. which is the third one here on the group. I don't know how many times I've had an employer come to me and say, we want to eliminate this job and we're going to let this person go. It's really a performance termination, but they don't really want to deal with that head on because it's uncomfortable, or they haven't documented the performance issue. And so we'll call it a job elimination and fill the job later. And that's not a job elimination, by the way. And so it doesn't really take the place of doing the work required for performance termination, but I digress. So job elimination, a group reduction in force, right? So that would be more of a group layoff, special roles, poor performance, or fit. So generally severance agreements we're using there. Now we also have, when someone's filed a charge or a claim of discrimination or a wrongful termination suit, those kinds of things, we have settlement agreements. And some of the same, there's a lot of the same provisions in those two agreements, because in reality, a severance agreement is kind of a settlement agreement. You're paying severance in return for that employee waiving claims against the company. So they're very similar in what's included, a little bit different in the setup language. But what's included in those agreements? So the terms of the separation, or if it's in a lawsuit, the terms of the settlement, consideration for the agreement. Anytime you have a contract, if you're not a contract lawyer, you might not know that, but you have to have consideration for that agreement, some type of value to the person who's giving something up. So if I'm an employer, I'm giving my former employee money in exchange for them releasing a claim against me. So that's the value exchange to the consideration. Sometimes you'll have non-solicitation or non-compete agreements written in those provisions. A lot of times it's someone who's maybe got a lot of client contacts or higher up in the organization, access to your intellectual property, and you want to protect that. Those provisions may be there. Probably the most important one for employers, the release and waiver of claims. Because if we're paying money, we want to make sure they're not going to turn around and file a claim against us or a lawsuit, and we'll be paying again. And we'll talk in a minute about some of the rules around those. Confidentiality, I have non-solicitation, non-compete again, I apologize for that. Confidentiality agreements, were really very standard, right? We didn't want employees, either ones we're terminating or those who filed a claim and we're settling that claim, especially in a settlement situation, talking about it, talking about the claim, talking about how much we paid for that claim. You don't really want that information out there, especially the next one that comes along, having that information. But there's some new issues around confidentiality agreements too. And then special provisions related to the waiver of claims under the ADA. So if the employee who's not going to get that agreement is 40 years or older, there's some special rules in order for there to be a release of a claim under the ADA, the Age Discrimination Act. And different sets of rules. One, if you're talking about a single job reduction or a person being let go, and even much more stringent requirements if you're letting go of a group of employees. And the amount of time you have to give them to consider the agreement is different for those as well. And then other required language, EEOC California. So California is a little unusual. They have a law that says if you're going to have an effective release and waiver of claims, there's certain language that has to be in that, and has to be, I think, a certain type font size. It has to be bold-faced and very, easy to see in that agreement. And it talks about the waiver of claims. If it's not in a California agreement, you're not going to have a valid release. So you want to be careful there. The EEOC also looks at those agreements carefully, and you need to make sure that that released waiver of claims doesn't include, that it carves out the employee's right to file a charge with the EEOC. Because even if they can't recover money for it, they can't waive the right to do that. So that's something to think about, and often state agencies too. So there's actually a lot of complications around these agreements, which keeps lawyers employed, I'm afraid. So a little more information on that. A couple of things that have been going on lately. The Tax Reform Act that came out, early this year. A lot of big changes in that, regardless of how you view it. And one of them that is kind of was downplayed, there wasn't a lot of publicity at the time about it, was there's a provision in the act that says if you have a confidentiality agreement as part of the settlement of a sexual harassment case, that the money you pay to settle that case is not a deductible business expense. So in the past, if I paid, as an employer, paid something to settle a case with an employee, that was a deductible business expense. If I put a confidentiality agreement in there, which most, as I said, that was very common practice, and then now it's not a deductible business expense, nor are payments to attorneys who are representing the parties in that lawsuit. This really comes out of the Me Too movement, the Time's Up, where we've been hearing a lot about all of these claims where they were settled. I think Harvey Weinstein, there was quite a few of them. There's others, Bill Riley. I don't know if they settled any under Matt Lauer, but if they had, they would probably have had that agreement. So in exchange for paying that complainant, the complainant agrees never to talk about it. And that's one of the ways that things like the Harvey Weinstein scandal continued for quite a long time and didn't become a big public conversation. And so the concern is by having those confidentiality agreements, these things can be kept sort of undercover and continue, right? And that perpetrator can continue to harass people. You know, there's another side of that coin I've heard, which is, are people going to be willing to come forward and make complaints if they can't know that, it'll be kept confidential? You can see which side of that you want to fall on, but this is the law right now. And the other thing I wanted to mention to you is arbitration agreements. Very often, not very often, but in a number of employers have tried to adopt arbitration agreements. So, you can have them in a severance agreement. So if there's a dispute, non-compete, any of those things, that it would go to arbitration. You also will see it in employment agreements, that if there's a dispute, usually towards the end of employment, that the parties agree they're going to arbitrate that. Arbitration is favored under the Arbitration Act, Federal Arbitration Act, and it has benefits in that, one, it's confidential, right? You're not in the courts in the public system. It's supposed to be less expensive. It's interesting because you really are talking about lawyers and discovery and hearings. So to the extent, it's probably less expensive, but not inexpensive. And then there's concerns on the other side for employees because obviously an employer has more resources and a little more power in those agreements. And so there's a lot of activity out there in the land of arbitration agreements as well that you need to be aware of. And the last speaker I want to mention is Mark Schickman. We work with Mark Schickman a lot, and he's going to be talking more about severance agreements. In the current environment, they're going to continue to be, I think, something we hear more about. And there is if you want to take a look, a guidance from the EEOC out there with lots of information from their point of view about severance agreements and releases of claims and what is and isn't okay. And really it's a document that also is there to educate employees about what that means when they sign these agreements. So those are our 5 topics today. We have just a couple of minutes left, and I want to spend just another minute on our conference in November. I will be there, so I hope I get to see you in Las Vegas in November at HR Comply 2018. As a webinar attendee today, you have an offer of $50 off the registration price. There's a code there for you to use and information on how you can register. You go to hrcomply.blr.com. We talked about some of the speakers, and again, you can go on the site and look at the agenda. There's a full agenda of some really great speakers, but one that I'm really excited about I want to mention to you. Not really a compliance one. This is kind of an added benefit, but if you've heard of Patty McCord, she was the Chief Talent Officer for Netflix, and she was responsible for creating Netflix's Culture Deck, which is a really well-known document around creating a culture of engagement and accountability in a workforce. And she's written a book, which is now a bestseller and often touted as something that all employers need to look at, especially HR. And so Patty McCord, she's also a dynamic speaker if you haven't heard her before. Patty McCord is going to kick off our conference as the keynote speaker. So I know I'm excited to hear her speak as well. That's one of the perks of my job. Anyway, so we hope we see you at HR Comply in November. Please take advantage of that discount and join us. And we hope you got some good information in the webinar today. And on behalf of Joan and myself, we want to thank you for joining us, and we hope you have a really great afternoon. Thank you.